A license or permit under DSHMRA isn't the only agency action may be subject to litigation. It's the action NOAA's taking. People can not just sue over the DSHMRA permit, but they're also going to sue over the ESA consultation. And so it's not just you get your DSHMRA permit and defend that in court and that's it.
Welcome to the Elements of Deep Sea Mining podcast. I'm Eric Young. Joining me today is Brandon Tuck, partner at Vinson & Elkins, specializing in environmental and natural resource law. Brandon, thanks a lot for joining me today.
Oh, absolute pleasure, Eric. Thank you.
So, I saw you gave a presentation at the Seabed Minerals Conference in Bergen where you talked, I guess the main pitch of your talk there was regulatory risk and how companies and actors in the deep sea mining space domestically in the US can best navigate DSHMRA and some of the domestic aspects. And that's something that we haven't talked about yet on this podcast. I've had a few international lawyers talking about interpretations of DSHMRA, things that are kind of coming up in the international discourse since the Trump administration put out some executive orders, etc. But I'm excited to have you on to talk about how DSHMRA actually kind of works and is supposed to work, which is, it's domestic U.S. regulation. So that's what we're going to focus on today.
Sure. And I come at it from a U.S. environmental law perspective. And one of the things that I think isn't fully appreciated in the international deep sea mining discussion is just how robust of a framework the United States has. So yes, DSHMRA seems to have come out of nowhere. A lot of people, learning for the first time, that's what the U.S. is doing. And a perception that with President Trump's executive order, with this, renewed approval emphasis out of DSHMRA, that NOAA is going to be issuing industry blank checks to go out and exploit resources in the area. And that's just not the case. And I think I want your listeners to understand that NOAA has obligations to perform a variety of reviews and consultations. And my specialty is in environmental law. I know a lot about what the environmental reviews and consultations will look like that NOAA needs to go through. And there's some pretty interesting aspects that are built straight into DSHMRA that demonstrate how much more robust that environmental review will be than most of the other environmental reviews that happen for other agency actions in the domestic space. And not just that, but there are other reasons why the U.S. participation in this isn't the wild, wild west. And that's the role of American courts, the judicial system. The role they play is they're going to hear challenges to agency actions. They're going to hear challenges to NOAA's permitting framework, to its individual decisions. And NOAA knows those lawsuits are coming. Industry knows those lawsuits are coming. And the best way to prepare for those lawsuits also happens to be the best way to ensure that the policy objectives of environmentally sustainable, environmentally responsible actions are met, while also supporting the policy objectives that are recounted in DSHMRA and the executive order, et cetera, to talk about developing a supply chain that's supported domestically and isn't subject to interference of foreign actors. And so I think those are the things that I bring to the table, is an understanding that it's not a open season for deep sea mining under the NOAA DSHMRA framework. There are a lot of steps they need to do that are pretty robust, and it's going to be highly scrutinized, and the agencies and industry are getting ready for it.
Tell me then how you fit into this picture. What do you focus on professionally, both with regards to DSHMRA and otherwise? And I get the feeling that one of the things that you do is to help people in the space prepare for those lawsuits that you're talking about. So this is obviously, there's a lot to be determined and litigated over, and part of your job is to try to get out ahead of that, help people prepare and anticipate exactly how those things might turn out.
Sure. My practice is built on project development. Most of my projects are large infrastructure projects, commercial, industrial, some residential, transportation, energy, you name it. If it requires a lot of time and development scrutiny on the environmental side, clients engage us to help them navigate that permitting process. What we don't want is that we come in after the agency has already granted a permit, already completed their review, and everything is done and set. And then project opponents litigate saying, well, the agency didn't consider this. They should have done this. They didn't respond to my alternative of X, Y, and Z. And the way that review happens in the United States is that agency action is reviewed based upon the record that was before the agency when the agency took the action. So this is a little bit of an administrative law primer. Agency actions are reviewed to ensure that the agency wasn't arbitrary, they weren't capricious, they didn't act not in accordance with law. And so the time to make sure that the agency is making the best, most defensible action and that they have a reasoned basis to make that action is before you apply, and then after you apply, and as you go through the application process, the environmental review and consultation processes, the public engagement, all throughout that, my role is to identify issues, advise clients on how I think they should be, sometimes modifying the project or modifying the approach, modifying the messaging, doing more science here. Here's what the legal standards are and how can you best meet those legal standards. Here's what the project opponents are saying. Here are the responses to that. Here's how we need to make sure that the agency is considering what they need to consider so that when that record closes and a judge reviews it, hopefully he'll see that the agency has acted reasonably, that they are able to defend their actions with information that was before them at the time. And so a lot of times I work on projects that take 4 years, 6 years. Multi-million and billion-dollar projects, they have a long, long lead time. There's a lot of engineering, there's a lot of development, site selection, a lot of studies that go into it. And I shepherd the environmental review components all along the way so that when you get out the back end with hopefully a permit in your hand, it's going to withstand scrutiny and you'll be able to say, yes, we did everything that was required, often and more. We've mitigated these impacts. We've managed the impacts. This is all disclosed. We responded to the public comments, and we can, Your Honor, proceed with developing or constructing or operating the project.
And so when you do this normally, I imagine that the doing this under DSHMRA, and when you say the agency in DSHMRA's case, that agency is NOAA that is evaluating the proposals, and so it must be different in the case of DSHMRA in that a lot of this is new, where in other agencies, other contexts, you've got previous case law, you've got previous decisions and interpretations of regulations that you're kind of working off of. And in this case, so does that make the information management aspect of this even less certain in that, DSHMRA requires a lot of information management. You've got to get all sorts of ducks in a row and submit those. And I'm wondering what direction to approach this, but let's talk just a little bit about what's different in the deep sea mining case as compared to kind of your normal workload.
Sure. I'll first touch on your question about uncertainty. Let's talk about what you want in a permitting program, and then we'll compare it to what NOAA has. What you want is clear direction by statute for the agency to be able to look back and say, all right, we understand our chart. We understand what Congress has directed us to do. You want experienced staff. And you want that staff to have years of agency practice working through ambiguities, figuring out how to apply the statute and the regulations in unique circumstances. And ideally, you want to have a broad waterfront of case law where disputes have gone to courts and where courts have said, all right, this is how we're going to interpret this word or this phrase. Yeah. Or this is how we're going to apply this. The statute might be ambiguous in this way. This is what it means. And they set that out. So those are the things that I think you want in a good, solid permitting program. Now let's look at what DSHMRA has and what NOAA has. DSHMRA, it's a little bit of an older statute. It's been dormant, but not wholly inactive. So there are aspects of it that do have some repeat practice, and there's a little bit there, but what you don't have at NOAA is a large phalanx of staffers who have done this for a couple of decades, who know where the problem spots are and have action plans and precedent and how they approach those things. We do not have a body of case law of judges helping interpret what DSHMRA means in different circumstances. All of these things are going to be coming. But right now, I think that a lot of the uncertainty that we see with NOAA is, do they have the manpower to do what they're doing? And how are they going to be developing this experience, developing this savviness and making decisions about what the regulations mean, what the statute means, what are the prudent ways to manage this permitting program? They're developing that as we speak. And each question that comes to them is really kind of a question of first impression, where they're needing to figure these things out right now. As the agency feels its way a little bit forward, there are going to be some false starts, some missteps, some redirection, hey, I think we're going this way and we need to pivot because they learn more and they respond to that. This is new for NOAA in this particular context, but this happens all the time.
Right.
Congress passes statutes all the time. They set up new programs all the time. And even in some cases, agencies rediscover programs from decades past or from generations past and, reinvigorate them or resurrect them.
Because I think one of the questions I imagine on people's minds then is, what are going to be the costs of this learning process if the first body over the bridge is the most bloodied? And is that going to be certain deep sea ecosystems as things get figured out in the beginning? I mean, adaptive management is one of the terms that gets used a lot in how deep sea mining should be regulated. And so how does that play in with kind of everybody learning together how to interpret DSHMRA in this new, more active context? Is there the ability to learn as we go in a safe way, or how worried should we be?
Yeah, I think I want to separate between learning how to implement DSHMRA in your office, developing a project or reviewing a project, versus adaptive management when you actually have vessels working in the deep water, recovering and getting feedback loops of these aren't the impacts we thought. And so though I want to separate those and talk first about the in the office work and decisions and changes. So I think that those at NOAA are in good faith working hard to implement the statutory requirements and the policy directives in a responsible way. And when you read the directives in DSHMRA, and when you read the executive order, and then when you read the requirements of all the other statutes and processes that they have to do, they've got a lot of sideboards. There is a lot of certainty about what they have to be doing. So I'm just going to tick off a couple of those sideboards. So Congress has mandated that when NOAA reviews these, they need to consider an applicant's financial responsibility, their technical capability. They need to make sure that there's a use conflict review so that whatever NOAA is approving, it's not unreasonably interfering with high seas freedoms. It can't conflict with treaty obligations. You can't have circumstances where there's going to be a breach of international peace. On the environmental side, you can't have significant environmental impacts. They need to manage any threats to life and property. Those are pretty tight sideboards that NOAA has in reviewing applications. And they are not acting alone in this. They have, as part of the statute and the regulations, a lot of engagement with other departments and agencies in the U.S. government, with the State Department being one of the most notable in the international space and freedoms on the high seas, conflicts, etc. So NOAA has those sideboards. Just how do they determine what some of them mean is where I think they'll be doing a little bit of feeling forward. So to take just one example, DSHMRA prohibits NOAA issuing a license or a permit where it's going to cause significant environmental impacts. That's a heightened standard. That's more strict than I'll use NEPA, the National Environmental Policy Act. NOAA needs to go through a NEPA review for issuing a license or a permit. And the generic NEPA standard is disclosure of impacts, identifying which ones are significant, identifying what mitigation measures to management, et cetera. But the agency can proceed with or without significant impacts. DSHMRA is tighter. DSHMRA says no significant impacts, period.
Interesting. Yeah. So as opposed to just being clear over what your impacts are and then leaving it up to the agency to decide whether or not those impacts are acceptable, DSHMRA has a stricter standard. Why do you think that is? I mean, and more broadly, like why does DSHMRA have all of these sideboards built in, given that it's such an old statute that in some people's minds, and you can reinterpret if my description of this is how you see it, but a lot of people think, well, DSHMRA was kind of a holding statute through the 80s and 90s while the whole deep sea mining landscape was getting figured out. And it's been in a holding pattern for, I guess, at least 20 years now, without major revisions. And then now it's getting implemented into sort of a new context. And so why does it have all the appropriate sideboards for the context? I mean,
some of them are standard sideboards that the U.S. uses in development in its own exclusive economic zone or in its own territorial waters, where, hey, if the government is going to lease out its subsea surface for mineral development or for oil and gas development, we need to make sure that the applicant comes with financial responsibility. We need to make sure the applicant actually has the capability to do this. Some of those are standard. When we turn to the different and higher standards of environmental analysis, I think it relates to the precautionary principle. I think it is because of the unknowns, and Congress wrote in a heightened standard because of the unknowns. So that's one approach to it. I think the other approach is in exercising freedom of the high seas, the U.S. recognizes the common heritage. When you open up DSHMRA and read the policy section at the very beginning, it goes through and it lists out probably a dozen different policies. And one of those talks about the U.S. vote in 1970 recognizing the common heritage. And I think that the U.S. appreciates that it is going out in 1980 as a unilateral actor, taking advantage of its freedom of the high seas, but that it wants to do so responsibly. And so I think that we have these heightened standards because the U.S. recognizes it needs to behave in a more responsible manner given the international dynamics. And that raises its head in a lot of other ways that I think that we'll get to later. But it's not just in that way that the U.S. framework under DSHMRA has many more levers to accommodate this interesting dynamic we have in the area.
Since you mentioned common heritage, can you say more about that? That was something that was surprising to me to learn, that DSHMRA has common heritage provisions built into it in the same way that ISA has some common heritage.
Sure.
My understanding in ISA is that that's very uninterpreted, unbuilt out yet. It's kind of an ideal with very little content to it. Is that similar?
Well, I'll read it to you. But that's exactly what this is going to do. This is the list of congressional findings. Congress finds that on December 17th, 1970, the United States supported by affirmative vote Resolution 2749, declaring, among other things, the principle that the marine resources of the deep seabed are the common heritage of mankind, with the expectation that this principle would be legally defined under the terms of a comprehensive international law of the sea treaty yet to be agreed upon. DSHMRA is, yes, it was intended to be an interim until there was a treaty that the U.S. entered. But this common heritage language, it isn't alone. I don't think I've heard others recognize that the DSHMRA framework also set up financial arrangements in a trust fund so that if there was commercial exploitation occurring under that DSHMRA framework, the monies collected in that trust fund would be turned over to that international body if the United States entered into that.
Really?
So that trust fund, I don't believe it ever had any funding because we only had 4 exploration licenses granted. But that trust fund was created. It expired because of lack of use. There was a provision in the statute of if there's no treaty within X number of years, then any funds would be passed to Congress to appropriate at its pleasure. So right now, there's not a congressionally active way to capitalize that trust fund. But that purpose was there, and that purpose is there. And I'll add even further that if you read the executive order, President Trump's executive order last year, it talks about a feasibility study. It directs that several of the departments get together and they prepare a joint report analyzing the feasibility of setting up an international benefit sharing mechanism. So these are things that I don't think many in the deep sea mining community appreciate, that DSHMRA is more environmentally protective and actually has some of these levers to help ensure that these resources are managed prudently or appropriately or with due regard.
Wow. It makes me wonder if there's ever been a functional fund that is distributed internationally, or if that is also just kind of in terms of global finance, a first of its kind. That sounds difficult. Okay, so one of the specific things that I remember you talking about in your presentation, which I think is good to get listeners clear over, is just what is the nature of the rights and obligations conferred under DSHMRA, and who are the rights guaranteed against?
Sure. So DSHMRA has exploration licenses and commercial recovery permits or exploitation permits. And DSHMRA is very clear. Congress spoke very clearly that those rights are only available to U.S. citizens, and they only provide you protections against other U.S. citizens. So they're not if you held a commercial recovery permit for a particular plot of seabed, DSHMRA only allows you to exclude other U.S. citizens from interfering with your activities. It claims no sovereignty over any part of the area. Mm-hmm. It is built upon the notion that this is a high seas freedom, and the permitted actor from the United States needs to behave with due regard to the international activities of others, but there is no exclusion. And this is another way that I think DSHMRA is helpful and protective. It has, as part of the decision-making process, NOAA looking at the potential for there to be conflicts. So during the review process, NOAA will be reviewing, is this, if we grant you this license or we grant you this permit, are we going to have a conflict with whomever? And so they require applicants to disclose any known conflicts. During the review process, NOAA will be coordinating with other U.S. departments, including the Department of State. They'll be analyzing the potential international conflicts that might arise with any particular project. And even after you have the permit in hand, let's say that you obtain the permit and you're out and you're engaged in commercial exploitation, you can't exclude other states from that location. And if you end up having the potential for interference, DSHMRA provides that, the Department of State or the Secretary of State would come in and use all peaceful means to resolve the issues. So there's this outward-facing diplomacy aspect built into DSHMRA, and there's
in that it specifically hands it off to the appropriate departments of government that are designed to do that international diplomacy, international interaction. So the boundary around DSHMRA is entirely U.S. domestic. If you happen to be a mining company out there mining, and I want to sue you as a Canadian mining company, I can't do that through DSHMRA because that's not an international statute. I have to go and elevate it to the State Department, go through some other means.
No, let's talk about litigation here in a few minutes. But yes, you would have some avenues to sue, but let's put aside, if we can, just the lawsuit aspect and just talk about actual interference. If your U.S. subsidiary wanted to exploit resources within my U.S. subsidiary's permitted area, I can exclude you, or the government can exclude you. If your Canadian entity was commercially exploiting, let's say under a future ISA program, if a Canadian entity is exploiting in the same area, NOAA and the State Department aren't going to seek to exclude that operation. They're going to seek to engage in diplomacy. And so DSHMRA doesn't purport to give the United States any ability to exclude in actual use. That's outward facing. DSHMRA also encompasses this inward facing risk management program, where once you get a permit, you can't say, "I hold this permit. I can go do X, Y, and Z. I have carte blanche permission to go do what I need to do." If or when a conflict arises, not just in use conflict, but it could be that the environmental impacts are different than what you originally studied. It could be that we have more information or new information about impacts that we didn't appreciate. Whatever those are, DSHMRA gives NOAA the ability to modify your permit, to suspend your permit, to step back in and add new conditions. So it has this outward diplomacy facing aspect and this inward managing your operations aspect. And all of those are just separate from some litigation avenues. But when you get a DSHMRA license or a DSHMRA permit, it's safe to exclude other U.S. citizens, but not others in the international space.
So DSHMRA's purview is going to be just on this exclusion aspect. This just occurred to me. If you've got a DSHMRA permit, that really gives you rights to the seabed. But if I want to go and fish in your exclusion zone or something, how does that get?
Freedom of the high seas. And then DSHMRA would say, you must exercise due regard. The rest of a lot of the customary international law provisions of how to take advantage of freedoms of the high seas, DSHMRA contains provisions that have DSHMRA or have NOAA looking at, and incumbent upon the company who holds a license or permit to follow those standards. And so you would not have the ability to exclude someone from fishing based upon your rights on the seafloor. Or maybe I should say due regard. You have the due regard obligation. You may be able to exclude them from actually trawling into your equipment. But that's a bit more than due regard.
Okay, I imagine you've got other specific aspects of DSHMRA that you think are worth kind of highlighting before we get to litigation. And also one thing is that DSHMRA has been recently updated, or there's been some modifications. At least the one that made the news over here anyway was you can now have a combined application process as opposed to exploitation. So I'd like to touch on that. Maybe just, or were there other aspects of DSHMRA that were updated along with that, or was that the main change?
Sure. So that update wasn't actually an update to DSHMRA. That was an update to the regulations that NOAA has that govern how it implements DSHMRA. So let me just take one step back and explain how this happens under U.S. law. So DSHMRA is an act of Congress. So Congress passes it as a statute. And in DSHMRA, it delegated the responsibility to manage this deep sea mining permitting program to NOAA. And it set out, section upon section of requirements, sideboards, considerations. This basically laid out process. All of those are things that NOAA, when they implement DSHMRA, they can't change any of those. They have to follow all of them. And what we saw earlier this year when NOAA finalized the change on consolidated applications, it was NOAA making updates to the regulations that it has provided that fill in the gaps, that tell industry, this is how we're going to do what Congress has told us to do. So you have a high-level statute. The regulations are this is how NOAA is doing these statutes. And so that change was actually not much of a change. It's gotten a lot of airplay, but I think it's actually pretty narrow and pretty surgical. The statute and the regulations contemplate that a company goes in and they get an exploration license, and they use that exploration license to gather the information they need to be able to gather the materials, do the studies, develop the proposal, and come in for a commercial recovery permit application. The original statute, or under the original statute, NOAA had predicted that at some point in the future, science and data collection and technology might have developed to a point that you don't need 5 years of exploration to be able to put together a plan to do commercial recovery. Right. And so they put a placeholder in their regulations where they said in Part 970, here's what you need to do an exploration step. And then after you do that, then here's what you do in Part 971 for you to do the commercial recovery step. And they left a little section in that basically said, to be filled out later, that said, at some point, there may be a consolidated path where somebody can apply for exploration and commercial recovery at the same time because they already have all the data they need. And we don't need to separate them and elongate this process. So
was there a time frame built into that process where there had to be a certain amount of delay? Because to my mind, I was always like, well, what difference does it make if you have to have all of the same environmental review data, the environmental impact management plan, whether it's in 2 different manila folders or together in 1 manila folder that you submit to NOAA? What does that really matter? I mean, this is exactly, I think, one of the things that Norway stumbled big over was not being super clear that there wasn't going to be any exploitation before substantial review after exploration. But I kind of wondered, doesn't this create unnecessary controversy or even just unnecessary additional backtracking for people who are already midway through a process?
Yeah. It under NOAA's regulations, when you go in for exploration, there are steps. You need to do a draft environmental impact statement. You put it out for public comment. You have hearings. You finalize the environmental impact statement. They develop the conditions on the license. And when you've completed that, then you can enter into the commercial recovery process, which requires an application, another certification step, and then another draft environmental impact statement, and then another round of public hearing and a final environmental impact statement. So what this consolidated approach was, it was to say, you don't have to do sequential separate EISs. If you've got the data to do it together, these are the particular steps you have to do it together. And when you read those steps, they include everything that you would have to do under exploration and commercial recovery into a single process so that you can do it with one round of EIS review. Whereas without that, the system was built that first go through your exploration EIS, get your license, and then you can go through the commercial recovery. So it's really just an efficiency measure. There shouldn't be any less process that matters. It will just be combining the review into the same environmental study and doing it together. basically just saving time for a sequential process that doesn't need to be sequential in particular circumstances.
And I guess we can say that, the circumstance in which it doesn't need to be sequential now is because the metals company has been doing exploration, gathering all of that data just through the ISA, their ISA exploration permit for the exact same areas that they are now applying for. So it is a situation where they have already been through at least a very analogous exploration phase. And so they are at the step of having at least a shot at having all of the right ducks in a row to apply for a recovery permit.
That's right. In the preamble, which in U.S. legal parlance, when NOAA revises its regulations, they do it by public notice and comment. And when they finalize those regulations, they write a preamble, an introductory section where they respond to comments. They provide additional context and color about what they're doing. They explain there that the consolidated process isn't necessarily the process for everyone. You might not have the data that you need to be able to get a consolidated license and permit at the same time, because if you haven't done the exploration work and you haven't gathered the data, then you might not be able to provide all of the component parts to make for a robust environmental analysis. And so NOAA wrote in that if you go in for a consolidated license and permit, but they are only able to make the findings that you meet the requirements for the license for exploration, but you don't have what they need to do the commercial recovery, then they will just issue you an exploration license. And you'll have to come back and get the commercial recovery. So this really hasn't created a substantive shortcut to what you have to bring to NOAA to do your commercial recovery. NOAA is still going to have to make all the required findings. And in order to make those findings, you need to be arriving with the data and the analysis and the support and the studies. And if you already have those from other activities that you've done, under the ISA for years, then you have some advantage there and it might make sense. If you don't have those, then I think that there will be lots of discussions on, well, are you able to put together those materials to get there? Or do you run the risk that NOAA is going to only be able to give you your license, even though you applied for both together?
Yeah, it's pretty hard for me to imagine what other circumstance could come up in which you can bypass doing the exploration phase. If you need a substantial environmental impact statement, it seems to me hard to imagine how you could get that information aside from doing that exploration work in a different context. And of course, the metals company might not be the only one to do the exploration work under ISA, and then so that there might be others that follow a similar path. But the other path of just going straight shot to exploitation seems difficult to imagine.
Well, I will just hypothesize a couple of scenarios. One is somebody else has already done the exploration and you don't need to do it. Number two, there have been two extensive studies, one to your left, one to your right, and you have a narrow band in between. And all available information is that it's consistent across the field. And so you can accurately predict that, well, we have the exact same geology, the exact same structures. And, basically your immediate neighbors went through this. Do you need to have that study done on your property when you look to your neighbor to the left, you look to your neighbor to the right? Of course, that has limits. I'm not saying that can be the maximum extent of your very, very large plot, but you've seen some of the outlines of some of these plots with little narrow necks going here and little things there. You might be able to do commercial recovery activities in small portions where you're using the study and science of the immediately adjacent parcel. So the consolidated framework envisions that might be the case. This isn't NOAA saying this is the case right now. It's just a pathway that, this might be what we have in 10 years or in 15 years or in 20 years. We're going to make this available now because there might be an actor or a couple of actors out there that this seems to suit them well. And for others, we might get there for them.
So then, to me, this naturally raises the question of what happens once, say, a recovery permit is issued. Then what else do the regulations specify about following up and monitoring? What's in there once you get the permit in your hand and can go and start the next step?
Well, we'll be anxiously awaiting what the first sets of terms, conditions, and requirements look like. But that's what the hard work is that NOAA is doing right now. They are determining what those appropriate, we call them TCRs, terms, conditions, and requirements, what those appropriate TCRs are to ensure that you don't have significant environmental impacts, to ensure that you don't have, and then we go through each of the other sideboards that DSHMRA provides. DSHMRA and a bunch of other statutes provide. So I think that it will contemplate that you're going to have those terms, conditions, and restrictions, and robust monitoring, and then adaptive management. All of those will be built in. Exactly what that's going to look like, not quite sure. That's what we'll see once the first couple of actors jump over go into the breach.
Yeah. I guess that this is something that there's analogs in other fields. There are other examples. I mean, land-based mining, you get a permit to mine, there's additional terms, conditions, and requirement that you have to report, monitor, and you don't just kind of get carte blanche from that moment on.
Right. Right. And I hear some others express some skepticism that, once you give a company a permit, they're gone. They're off on the horizon, and you're not going to know what the actual impacts are. They're going to hide those impacts. And so this is always the case in the large projects that I work on, that I advise on, where there is community opposition, where they say, yes, but we think that things are going to be worse than what you think. And nobody's going to police it. There's going to be no enforcement here. And I wanted to note that DSHMRA has some pretty robust enforcement measures and provisions. If you have a company that holds the permit and they're out there violating the permit, not only do they have all the monitoring obligations and disclosure obligations, but the penalties that can come to them are pretty significant. NOAA itself can penalize them $25,000 a day per violation, and that's per day. And so you can get to millions and millions of dollars of violations in a very, very short order. There are criminal penalties where those go up to $75,000 per day plus imprisonment. And you can lose or forfeit your vessels. You can forfeit the minerals that you recovered. So those are the things that are hanging over a contractor's head. So I think that it's a bit nonchalant to say that there will be bad actors that are out there hiding their non-compliance, because the enforcement mechanisms and the monitoring, those tools will be there. And I can attest that the U.S. government does not frequently shy away from bringing front page headline, put out press release actions against what they perceive to be bad actors who flout their environmental law.
Yeah, that is something that I think everybody is interested to see how that turns out. And this is something that is certainly not just a United States issue. It's anywhere you're doing environmentally impact activities that are difficult to monitor and 4 kilometers beneath the ocean,
Right.
Hundreds of miles from shore is certainly one of the places that people have concerns about.
And if it's the case that some of the deep sea mining scars from the 1970s still appear just as they were, how would you be able to obfuscate non-compliant actions on the seafloor? I think that it would be there and would be visible to third-party monitors should they choose to go. Is point number one. Point number two, DSHMRA has third-party private lawsuit openings. And so, Eric, if you wanted to bring a lawsuit against NOAA, DSHMRA tells you how you can sue NOAA for granting permits not following the processes that DSHMRA required. And DSHMRA gives you, Eric Young, the ability to bring what we call a citizen suit, that if you say, well, NOAA's not bringing an enforcement action, and I think they should. DSHMRA says that you can give NOAA 60 days notice that, hey, they're violating this. And if NOAA doesn't take an enforcement action within those 60 days, then you can go into court and you can be the one who's bringing the enforcement action against the company. So there are a number of U.S. environmental statutes that allow these types of citizen suits. The Clean Water Act, the Endangered Species Act. If someone takes or kills an endangered species, the government isn't the only one that can hold that responsible party to bear. Private citizen can bring citizen suits alleging violations of those statutes. So I think that there's more opportunity for that. Earlier in the discussion, I cut you off on the bring a suit for violation of these norms. These would be suits for violation of DSHMRA, not suits for violation of, hey, we think that you're doing something in international waters that's subject to international law. I mean, you might have a judge that listens to some of that before making a decision that he perhaps lacks jurisdiction to hear it. But that judge would certainly be hearing and entertaining claims of a permittee who's not complying with the conditions of the permit, and plaintiff brings evidence that demonstrates that they're not. That court would consider those claims. I
guess on the practical aspect of this, I can just hear people saying, there's more concerns than just that someone will mine somewhere that they're not supposed to, or there'll be visible evidence that can be found. There's the possibility that there's a requirement to monitor and submit species identification or something, and that there will be incentives to avoid submitting samples if you find new species, et cetera. And I think this is something that I think about a little bit, and the best argument that I've heard in my head, and this isn't really the topic of this podcast, but when these ships are out there doing recovery, they're spending a lot of money on cruises, and there's going to be opportunities for collaboration with research initiatives to also be out on those cruises. So far, there's never been, to my knowledge, an exploration cruise that, wasn't kind of being jumped on by as many researchers as possible who want to get out there and get down to the bottom of the ocean while they're putting the equipment out there. So to me, the most kind of optimistic scenario is that there will just be synergies between the recovery vessels and research vessels, in that there will be some sort of third-party monitoring, and that will be easier to, I'm sure there'll be some monitoring required in the terms, conditions, and requirements, and that maybe that will happen cost-wise, synergistically, because it will be valuable from a research standpoint. I wonder if it's time to get to the litigation aspect, or if you have any more kind of specifics of DSHMRA that are worth bringing out. Yeah,
so I think I already touched on some of those litigation points about how citizens, third parties, and I say citizen, it doesn't need to be a U.S. citizen, it means any person. So those litigation avenues are there. I think a couple of the other points that I would make on the litigation front, and this has to do with what we do during the application and agency review process. No one knows that there's going to be lawsuits over these licenses and permits. Industry knows that's going to happen. And so what can you do now to address some of those litigation risks? And I usually categorize those risks and then talk about what some of the mitigants are. So we know that first movers are going to have heightened litigation risk just because they're the first ones in. And the agency is trying to feel out what they're doing, and there will be some lessons learned from those first movers. I'll talk through the mitigants of the first mover risk, and then we'll have those same mitigants apply to some of these other risks. But the permit review process and the environmental review process is an information and science and technology and documentation intensive exercise. And the more reasoned analysis there is, the better chance you have at withstanding brand new lawsuits, first of their kind, And so, particularly in the deep sea mining space, where there's a lot of uncertainty and a lot of statements of we just don't know enough yet, so we just need to hold back until we know more and know more and know more.
Mm-hmm.
The way to defend that is to make sure that you demonstrate that you know enough to meet the standards. And what you don't want is the agency suggesting that it is doing any shortcut. The applicant suggesting that the agency ought not to look under this rock over here for this impact. The more fulsome your review and the more transparent that review, the better your arguments would be in litigation. And so another way that the DSHMRA environmental review process is more robust than the environmental review processes of its other actions or other agency actions under environmental law in the US is that NOAA has to put out both a draft and a final environmental impact statement. They have to have a public hearing. They have to respond to public comments addressing those things. And there's been a sea change in US environmental law and regulation on just when you have to have public involvement and the degree of public involvement. Right now, for its other actions, not under DSHMRA, but the other actions that NOAA might take, NOAA doesn't have to do as public facing of a process. They don't have to put out a draft EIS. They don't have to have a public hearing. DSHMRA requires all these things. And I would submit that requiring those things and doing those things is what we need. It's prudent. What you want are all of the voices to come and, hey, bring your concerns, identify what you believe to be the impacts, identify what you believe to be the soft spots in the methodology, identify what you think the appropriate alternatives are, bring all that to bear so that the agency can go through all of that and comes to a reasoned decision. It's unhelpful for an opponent to lie in wait with I've got a gotcha argument that they're not looking at X, and you wait in the wings and you wait for the agency to act, and then you jump in and pounce. Some U.S. courts allow that. Many U.S. courts don't allow you to manipulate the public process in that way. So here we have these public engagement milestones where you can mitigate some of the risk just by let's hear those voices, let's hear those ideas, and get them down and give the agency an opportunity to grapple with all of them and respond to them, work through the issues. So that's I think the primary mitigation that we would have to address some of that litigation risk.
Yeah, and I mean, you have to imagine that in this, like you sort of referred to, in the environment that deep sea mining is being developed in, there's so much pushback, there's so much polarization. I have to imagine that everybody, both in NOAA and any of the companies who are taking this route, are anticipating, expecting that there's going to be people are going to be putting up lawsuits kind of as soon as they can and all throughout the process. And so it's relevant what you're saying, that everyone is going to be trying to get out ahead of that as much as possible ahead of time. Interesting what you said about how the courts frown upon people who wait until after the public process is done to bring a lawsuit when they could have brought some of that earlier on in the public consultation process. That's interesting to note.
That's right. I'll quickly cover a couple of other litigation risks. One is I sometimes call this the waterfront risk. A license or permit under DSHMRA isn't the only agency action that may be subject to litigation. It's the action NOAA is taking, but there will be other components and other processes that NOAA has to do in order to finally get to where it issues its action. So just as an example, there will be Endangered Species Act consultation requirements. And depending on what those impacts are, that can result in certain type of findings and decisions and steps that themselves can be the subject of lawsuits. If you're going to impact marine mammals, you might need particular actions under the Marine Mammal Protection Act. Well, once again, people can not just sue over the DSHMRA permit, but they're also going to sue over the ESA consultation. They can also come in and sue over the Marine Mammal Protection Act. They can, participate in these other avenues. And so it's not just a silo. You get your DSHMRA permit and defend that in court, and that's it. I think opponents will be looking at all the different ways that they can try to stop your project. And it's not only the actions that you're doing on the deep seabed. We've not talked about what DSHMRA says and what the executive order says about U.S. domestic processing facilities that are supposed to be the ones that receive all of what are authorized under DSHMRA. DSHMRA is designed to incentivize and help create an entire supply chain. Mm-hmm. And so opponents can not just attack or target the DSHMRA action, but they can target the port and they can target the processing facilities on the mainland and target the myriad number of environmental approvals that agencies need to take that will be subject to potential litigation. Two more quick risks. One is an accelerant risk. Anytime you have an administration saying we're streamlining these reviews and we need to get them out quicker and faster, you will have tension. You'll have tension within the agency and tension between the agency and the applicant, where on one side you will say, well, we need to be moving faster. On the other side, you will say, we need to do this right. And sometimes right just takes more time. And the statute, DSHMRA itself, has mandatory timelines. It has timelines for you to be able to get through the draft EIS and final EIS stages that are tied to 180 days each. And I mean, I would say it might be better for NOAA to miss that timeline and prepare a more robust EIS if it takes an extra month than to meet that timeline, 180-day timeline, where, you know what, in the end, in litigation, maybe you would have wished that we'd spent 6 more weeks responding to these arguments and doing it better. And the last risk is what I call long tail permit risk. And that's the risk of a future presidential administration deciding to retreat and say, yes, DSHMRA is here, but we're not going to streamline them and we're not going to do this. And we're going to downplay some of this. So that risk is there. It's a political risk. You can do some buttressing against that political risk by not doing shortcuts, by being thorough, by being scientific, following the steps. Because it's easy for a new administration to come in and say, they were giving you a rubber stamp. They were giving you easy outs. Right. But if you have been thorough, then it will be more difficult for a new administration to undo things that were done robustly and with thoroughness.
I mean, there's some sort of remedy, right? If there's a law saying that you have the right to do something, and then and you spend a bunch of money starting to do that thing, and then the government changes its mind and says, actually, that law doesn't count anymore. That surely can't be just kind of allowed to have companies just kind of run to the end of a runway and not have anything be there. How does that work?
You've just described what in the U.S. offshore wind world has been a very, very hot debated topic and litigated topic, where there were a lot of development projects within the EEZ. So offshore wind companies getting leases from BOEM and then developing projects, and then a new presidential administration comes in and says, I don't like offshore wind. I'm going to stop you and stop you. And as of right now, the formal attempts to stop construction on those projects, while temporarily successful, were all overturned in litigation before different federal judges. And so there would be a fight.
Yeah.
In the offshore wind context, there were actual lease payments, and we have a real estate interest in development at this area. So that's a little more solid than what you would have with a DSHMRA permit, because the U.S. isn't leasing you land. The U.S. doesn't have the right to exclude anyone from that portion of the deep seabed. So I think you're one layer removed, but those arguments, considerations would certainly be there.
Okay, so then, I'm interested in getting your perception of. I imagine that the kind of deep sea mining world has arrived on your desk more recently, and you've got a lot more experience with other environmental and infrastructure build out, but a lot of those would have also been controversial. So you've put yourself into the controversial space, being a lawyer. So I'm interested in how the deep sea mining kind of milieu compares to the other things that you've worked with.
Yeah, I think that there are a lot of apt parallels. I have worked on and currently working on a number of different projects that some are energy, different aspects of energy transition, traditional oil and gas, renewable, geothermal, across the spectrum where there is a lot of contention. And in thinking about how I view that contention and that friction and how to navigate that, one of the things that I come back to, and this is the true lawyer in me coming out, is that I believe in process, and not just the specific process of going to an agency and getting a permit and then building a project. I believe in the system of governance that we cooperatively agree to. In the lawyerly world, we believe in the rule of law, and that laws actually mean something. I recently had a project that was working to get an approval from from a group of elected government officials, a council of officials, and the agency decision maker asked me on behalf of my client, said, "Well, why don't you, instead of coming to us going through this permitting process, why don't we just put this up to a popular vote? We'll take everybody in this area and we'll just hold a special election. And if everybody votes for it, then you get your permit. And if they vote you down, then you don't get your permit." And I think that you've had a guest or two who has noted that, hey, there some popular sovereignty aspects of deep sea mining. And I would say that it's a little bit of a false impression. Right now, in the United States, Congress has created a framework. Congress has spoken, and those congressmen and women who voted for DSHMRA were themselves elected by the popular vote. So they've created a program, a statute, and it's been delegated to an agency, and the agency is going through, doing and implementing and executing. And I think that the dialogue over disagreement about that, I think that we should look at it in terms of, well, what have we agreed to? What's the system here? And as part of this system, there are avenues and opportunities to participate in the process. And so under DSHMRA or under the Clean Water Act or the Clean Air Act or the Endangered Species Act, you name the permit program that's in an area of my specialty, I will routinely say, well, the agencies have spoken about the policy. We have a framework that's here. It's an existing framework. This is how things play out under this framework. And then opposition is very, very good. And I respect the opposition at identifying where in the framework you can move levers. You can expand or contract. You can to use some very specific environmental examples. Hey, there's some more uncertainty here. And the program that exists allows us to address some of that uncertainty by being more conservative on mitigation measures, more conservative on monitoring measures, more forward-leaning on adaptive management. And so let's maximize those within the framework that we have. Where I struggle is that for some opponents, they just say, I know that you have a path for you to be able to get a permit here. I just disagree with it. Yeah. And I don't think that you should get one. And I'm gonna petition for you not to get one. And my answer to that is, but that's not the rule of law. Petition to change the law, I understand, but participate in the process and provide all that you can to help, guide and pull the levers that you can pull. But we do have a process. Eric, what I appreciate about your analysis is you're asking this question not in the U.S. environmental space. You're asking this question in the area where there isn't yet that entire rule. It's still emerging. And so I have a US based answer where I say we have a program. You get a different answer when you turn and talk about this in terms of the ISA.
Yeah. I do think that in the abstract, process is something that people forget the importance of when it's working well. And it's in situations where process breaks down that it kind of people realize how important it is. And it is very easy. This is something that I am sort of researching on in my PhD in the philosophy context, is like, how do we make decisions? If we're making a one-off decision, then we have to bring in all of the information available to us. And that's really difficult. And this is where process, repeatability, and also having multiple sides of a question, multiple viewpoints, all be able to access the same process. There's all of these aspects to process that I think people realize are super important, but often not until somebody that they disagree with gets to make the one-off decision. I thought it was just very interesting what you said about, well, why don't we just leave this up to a vote, and the voters can just always make the decision about what to do in whatever situation. That always works fine as long as you agree with whoever gets to make that decision in the end. And I think especially kind of in response to populism becoming a more prominent aspect of governance around the world, people are realizing that populism is sort of an alternative to process. And populists kind of say, well, I don't want to do the process. I want to do what's popular. I have a majority. We're going to do this thing because we have enough people who support us, regardless of a fair and balanced process. So I think that's a super interesting and valuable point to push on. And then the aspect that I'm interested in hearing kind of your legal experience on is part of the legal process is this adversarial piece where, like, in certain situations, we've determined that the best way to get to an outcome is to put the proponents on one side and the opponents on another, and let them bring as much information and persuasion as they can muster. And that's going to be the process that finds its way through the information landscape to what we can kind of accept as the best outcome most of the time. So yeah, just given that you work in conflicting areas, is there times when you wish that there was less adversarial approach to these questions? I mean, this is, I think, how I feel often, especially in the deep sea mining debate, is I wish it was less of a debate. I wish it was more of a conversation. That's what I try to do in this podcast, is get people to listen to one another and see that there's just real, genuine people on different sides with different opinions. I mean, how do you feel about adversarial process and alternatives, and how do we get everybody to just get along?
There are a lot of projects that I work on that have a mixture of an adversarial process and a collaborative process. The adversarial process, I think, is a necessity when the goals and policies of one party do not overlap with the goals and policies of the other party, where we draw a Venn diagram and there isn't any shared space. So if you have an agency and a statutory program that says, hey, we want to secure a domestic supply chain for these minerals, and we're gonna do it in this sustainable way, A, B, and C. For those who oppose that and say, but I just don't want you to do it. I don't want you to even exist. There isn't that much opportunity for collaboration in that, because they have polar opposite aims, and it's, entirely inconsistent. For some projects that I work on, you may have an environmental NGO or an interest group that cares about a particular issue, and they may not oppose your project holistically, but they oppose your project to the extent that it touches on the issue that they care about. And those are situations where we are able to go out and work collaboratively, where, okay, I'll use a wetlands example. You're worried that this project is going to result in the filling of wetlands, and it provides this habitat for these species, and it's this green buffer area in your community. You want these values, and you're fighting our project because you want to preserve those. Well, let's talk about ways that we can work together to create conservation easements or buffer lands, or we will provide mitigation at a ratio of every acre we fill, we're going to give you 3 acres of higher quality wetlands than these, and they will be over here and will be protected into perpetuity. You come up with solutions to those. Once you know what their concerns are, then you can work together to, it's overused, but win-win. And that collaborative approach, it exists. It exists on almost all of my projects. But it's not feasible when one side says, when each side has an entirely incompatible goal.
What about when the perception, and this is something that you kind of mentioned to me the last time we spoke in person, what about when the perception of being a strong advocate is like outweighs the value of taking that position? Like, are there times when people could take in a collaborative approach, but they psychologically prefer someone who just fights really hard for their cause, and you're sitting on the sidelines thinking, you know what, guys, you're not doing yourselves any favors. This is making you feel good, but it's costing you?
Yeah, I love that question. I very often think about what's my role as an attorney. I'm a lawyer who advises clients, and that client advice is often never sees the light of day because it's me advising them. And we have some clients who say, if we give an inch right now, other people are going to take advantage of us in these other circumstances. We've got to hold the line. We've got to hold the line. And, in attorney-client discussions, we talk about, well, let's explore the risks of that. Let's explore the opportunities that are there. And I'm going to lay out how I see this playing out. But of course, it's the client's decision. And then they decide, and then we work to implement that decision. But I certainly have clients who would much prefer the collaborative route. A collaborative route is often less expensive in building a project. And I say less expensive in terms of dollars spent, time to develop, everybody's worry and stress, the risk that you might have, the public relations, reputational risks that you might have, projects that they need to go to banks for financing, want to remove any of these clouds of uncertainty, and so they may be more interested in a collaborative approach, so that they can get through the diligence reviews that the investors in environmental counsel will be pointing out, saying, yes, but what about this community? What about this impact? And what about this? And if the company is able to say, yes, they're on board, we've engaged with them, we've worked this through, your projects have greater certainty, fewer risks, and that leads to greater value or greater valuation. Other clients have different priorities. They may be self-funding. They may have had very poor experiences where they will say, look, no deed goes unpunished. Last time I went above and beyond and offered this, and now that's the new floor, and that's what I have to do on everything. And what they're actually wanting now is even more and more, and it's incremental, and we can't manage that creep in a way that we find sustainable. And so different companies take different approaches, and on all of them, we're behind the scenes advising on, here's the risks, here's the opportunities, here's how we think this plays out for you, and advise them, and then they make their calls.
Yeah, I think that also goes for people in oppositional positions, the groups, organizations who are trying to oppose a development. They also have to determine whether they're going to go pedal to the metal and try to get as much as they can, or compromise and get some safe wins and give up some things along the way.
And there is, this is an industry, consulting and advocacy and public engagement and organized opposition. To be very frank, it's an industry, and sometimes organizations will choose to fight not because they think they have a winning legal argument, but because it's terrific for fundraising, and it's terrific for profile raising, and or maybe they don't really care about that particular project, but there's some legal issue that they want to move the needle on, in this particular jurisdiction. So in the United States, different states are in the federal system under different appellate courts. And you might have a project where the agency is doing something that's routine in that area, but a group wants to come in and try to change the law. And so they're going to come in. They don't want to wheel and deal with you. They're not there to talk about your project. Actually, they're there to move the law, and your project is just the vehicle for them trying to change the law. And so in those circumstances, it's not about your project. It's about them changing the scope of review that an agency needs to do when it's addressing this question under this statute, so they can then use that for other projects that they actually do care about.
Yeah, or even just trying to move the needle on kind of the collective consciousness around a topic. It doesn't do, if you're trying to get the society to put value on a thing, it doesn't do to negotiate and trade away and have a small issue when what you can move the needle on by being loud and being firm and getting people engaged is a bigger topic. This is something that, I often feel talking to so many people in the deep sea mining space that it would be nice if everybody would be a little bit less arguing their position and a little bit more really working to come together. But there's a number of things getting in the way of that.
Yeah.
Okay, Brandon, we've been at this now for an hour and a half, so thanks so much for all of your time and insights. Is there anything else you would like to touch on before we wrap up? Is there anywhere you would encourage people to... I normally ask what resources, publications, where do you send people who want to have more information on the things we've been talking about? I don't know if you've got any suggestions for where people should go.
I think, based upon some of the points of discussion that we've gone through, I think I would recommend, and this would be a very light read. It wouldn't take very long, but for your readers to go and open up the DSHMRA statute and read the very first section on congressional findings and policy. It's the dozen bullet points. And then to do the same thing with the President Trump executive order. And then last, to do the same thing with the National Environmental Policy Act. Just look at what it sets forth as the policy. DSHMRA is a nearly 50-year-old statute, but if you read those policy points and findings, it could have been written yesterday on most of the points. And there's a great echo between those and what's in President Trump's executive order. And those policy points keep coming up over and over in the discussion in deep sea mining, both with ISA and with respect to U.S. activity. It's those same. And so I think that's what I would point to provide some extra reading or reminding of what those say.
Great. Okay, well, I will put links to those in the notes on whichever podcast player you are listening to this on. Brandon, where do people find you if they want to connect or follow or get in touch?
Sure. Our website is belaw.com. We maintain a pretty active space there, writing and thinking not just about deep sea mining, but about the other environmental programs that touch on this: NEPA reviews, endangered species, infrastructure development, all the things that I think are fair game with good overlap for deep sea mining.
Okay, great. Okay, well then, Brendan Tuck, thanks very much for your time today.